There's been a huge explosion of interest over Brendan Kavanagh playing his piano at St Pancras Station, leading to lots of questions such as, is this a public place? Is there a right to privacy in this place? Some people commenting this is a private premises because it's a railway station, therefore these rules don't apply, and all sorts of things. So I thought, what better opportunity to talk about what is a public place, and do you have a right to privacy in a public place? Just to address some of those questions once more. Now, I found this really interesting because I did a video on this at least a year ago, if not longer, because there are lots of different cases talking about what a public place is. Now, this is really important because some offences can only be committed in a public place. And then, of course, I'll talk about the right to privacy and whether or not there is a reasonable expectation of privacy in these places. And just as a heads up, if you do value your privacy, I have a partner for this video, which is more about them a little bit later. So let's talk about these cases, shall we? This first case of Knox and Anderton in 1982. The simple issue in most of these cases was the question, is it a public place? Now, in Knox and Anderton, this was talking about the landing area of a block of flats. Now, the interesting point about this case is that there was unhindered access for the public to access this upper landing area. And therefore, was that a public place because there was unhindered access for the public? The decision of the court was that it could be considered a public place because the general public had access to it, and more importantly, in this case, the public were using this as a shortcut. Thus, the court deemed that this was a public place because it was used by the general public, and so that kind of scenario, if that pops up again, it's a public place. And so if there's an offence committed that can only be committed in public, such as one of the public order offences, then one of those may be committed in a place such as the upper landing area of a block of flats. How about then Williams and DPP, Directorate of Public Prosecutions? The issue here was again about the upper landing area of a block of flats to which the public had access. However, the decision in this case was that it was not a public place. Why? Because this landing area, the reasoning given was that this was a restricted area that the general public did not ordinarily have access to. So in that sense, it was differentiated from Knox and Anderton in that the general public did not ordinarily and readily use that area because it was a restricted access. How about Harriet and DPP? This was whether or not it was a public place just because there was unimpeded access. Now, this is a very subtle distinction between the Knox and Anderton and the Williams and DPP case, where there was general unhindered access, and whereas in Williams and DPP it was restricted access, in Harriet and DPP it was unimpeded access. Now, the difference here was that this was a forecourt area between a hostel and the main road. And now the question was whether or not this was a public place because there was unimpeded access. So again, looking at the other case law, the court had to determine whether that was a public place, but held that it was not, for the reasoning that merely having unimpeded access to an area does not automatically classify it as a public place. Anderson and Miller was another interesting case because the issue here was whether the area behind a shop counter was a public place for the Firearms Act 1968. The decision here was that it was a public place because the entire shop was reasonably a public place, which included the counter because it was considered to be one unit, and therefore the area behind the counter was considered to be a public place for the purposes of a firearm in a public place under the Firearms Act. The case of Corley and Frost of 1976 was also interesting. The issue here was about a football stadium and a speedway track within the area, and was that considered to be a public place? The decision of the court was that both places were deemed to be public places. So even though ordinarily the public might not be allowed on there, the premises including the speedway track were accessible by the public and therefore considered one unit, and therefore they were both determined to be a public place. So you can think about how now we're going to talk about the railway station in just a moment. You can probably gather, but this is what the court will do, go through various different cases and analogies and determine whether or not a specific place is a public place. So I get a lot of questions about data protection and protecting your own personal information because lots of people have their identity stolen. Indeed, many people suffer frauds and they come to me as a lawyer to help them sort this out. So I'm very pleased to partner with Incogni for this channel because they genuinely offer you a very good service in helping to prevent your information getting out in the public domain and into the hands of bad actors in the first place. So how does it work and why is it essential? Well, if you think about when you buy something, you hand over certain bits of information, your name, your address, your telephone number, your email address, and then for certain things you need to give out your date of birth and various other security details as well. You see, some of the companies that you contract with will sell your information onto other companies. Now, you might think this is really bad, and in fact, it is quite bad. They are selling you as a package, your information. But within reason, that's perfectly legal because usually, you know, those cookies that we're all sort of frustrated with, those cookies that you agree to, and even the terms of conditions of a contract that you agree to will allow them to either share or even in some cases sell your information to another party. And eventually the bits of information about you might end up in the hands of someone who is then going to try to steal your identity to obtain money or goods by deception. So what does Incogni have to do with all of this? Well, Incogni will contact each of these marketing companies that collect and then sell your data and require that it is removed from their system in accordance with data protection legislation. There are hundreds of these companies that collect your information with the principle of selling it on to other people. And if you went out to find these companies, they've got all sorts of strange names and you might not even know what they do as a company, let alone whether they've got any of your information. But Incogni's sole purpose is to go out and find these companies that market you and sell you as a collection of bits of information and require that they remove you from their systems in accordance with data protection legislation. It's very easy. You sign up, you tell them who you are, and then Incogni will go and do all of the work contacting these companies to remove you from their databases. There's an exclusive discount in the description below using my code, which I'll put on screen right now as well. But if you think about the number of companies that you've genuinely dealt with, and then in turn they've sold it on to other companies, and now lots of other companies have got your information, the ones that you really need to be worried about are those that are actively trying to package it and sell it. Because then eventually it might end up on what's referred to as the dark web, the bit of the internet that no one really talks about very much and that the search engines try not to index. If you listen to some of the stories and some of the clients that have had this happen to them, they've had their whole lives turned upside down because of a contract, a loan, or something taken out in their name. And they've gone through hoop after hoop to try to resolve it. So do yourself a favor, it's a very small fee with an exclusive discount from me to you in this description below, and you'll have peace of mind knowing that the process is underway to eliminate your data from their servers. So thank you for allowing me the time, and now let's get back to those case law. Looking at Crown and Kane of 1965, this concerned a private club with a difference. It allowed access to members of the public. So therefore, the court determined it was a public place because whilst it might have been a private club, it did allow access to the general public. So you might infer there that if it didn't allow access to the general public, it's a private club, therefore a private place. But because this place allowed access to general members of the public, it classified this as a public place. How about Crown and Waters in 1963? Now, this was a closed hotel car park. Was that a public place? The court held, leave me what you think in the comments below, the court held that it was a public place because despite being closed, there was no barrier preventing the public to have access, which made it a public place. Some of these things have popped up in news in the last year or so where people have accessed a car park and received, to all intents and purposes, a fine, but a parking charge notice perhaps, because they've been on the car park when the company was out of hours. Now, there's different arguments at play there, perhaps contractual arguments. Was it right that a person is held to a contract if they enter a car park out of hours? But in this case, we're talking about whether or not it was a public place. Now, again, similarly to a previous case, there was no barrier preventing the public from accessing this place, and thus it was deemed to be a public place. Another interesting case is Elkins and Cartledge of 1974. The issue here regarded an enclosure into which people were invited, and was that a public place? You can probably gather from the tone of the rest of the cases if the general public are allowed in or invited in or have unhindered access and ordinarily access it, then it might be a public place. And that's exactly what the court held in this case. It was determined to be a public place because the invitation for people to enter the enclosure from the outside classified it as a public place. The next one, I don't know if I'm pronouncing this correctly, but Wilson and Skok of 1949. This was about the rear garden of a house, and someone was shouting abuse over the fence. And it was argued that this abuse could be held well over the fence into a public space, and therefore was it a public space from where he was shouting, even though he was in his own garden? Now, you might think that this would be wrong because it's his own back garden. And you'd be right, but not at first instance. Initially, the court ordered that he was bound over to keep the peace. But the divisional court ultimately said that was wrong because it was his own garden and therefore not a public place. And just because people had access to the front door or even going around the side or something, it didn't make the rear garden a public place. Similarly, in Crown and Edwards of 1978, this issue was regarding the front garden, whether that was a public place, and it was held not to be a public place. Again, access to the front door by members of the public did not make the front garden a public place for the purposes of various bits of legislation. So coming back to talk about the train station and this situation here, and whether or not this is a public place, well, you can clearly see that the public have and regularly do use unimpeded access to the train station. So whilst it might be a private premises, of course shops are also private premises and they can have their own rules that I'll come back to in a moment. But just because they are a privately owned premises doesn't mean that it's not a public place. So pulling all of those case law bits of analogy together, if a place is generally accessed by the public, there is unimpeded, unhindered access, which is regularly used by the public on payment or otherwise, that makes it a public place. So regardless of it being a private premises, so this will clear up a lot of questions, no doubt, about supermarkets and things like that, they are a public place, even though there might be a private premises. Contrast that with your own home. Now, you might invite a friend into your home, but you're not inviting general members of the public regularly on a daily basis into your home, I would think. And so your own home is not going to be a public place. Even if you were, for a short period, inviting general members of the public into your house, let's say for a house viewing, that would be for a limited period in time and not a definitive statement about your house. And therefore, if that went to court, I'm not sure that it ever has, but if that went to court, I expect that a court would rule that it's not a public place just because for a short period of time you have members of the public coming in to have a look. But generally, it is a private place, and so it's not a public place. But again, talking about this, now we've established that this is a public place because members of the public have unimpeded, unhindered access, which they regularly use. However, whether it's a railway station that's privately owned or a shop that's privately owned, they can make up their own rules, such as no filming. And if you break those rules, they can ask you to leave. But that is a very different question and a very different argument, very different point of law than whether or not you have a reasonable expectation of privacy in that public place. Now, let's contrast this very busy railway station or a very busy supermarket with, let's say, a spa, a salon, or some kind of medical clinic or treatment centre. They might be a public place per case law because the general public have access to it, they're invited in and so on. But do you have a reasonable expectation of privacy in those places? You can probably very quickly see the difference between the train station and the supermarket versus a medical clinic or even spa, massage parlour or whatever. Those are very different places. So now, whilst both places doubtless have rules about no filming, I think virtually every supermarket probably has rules about no filming, and they can enforce those should they wish to, make it a private premises to you if you're filming and they don't like you filming there. They could do that. But whilst most of them do, most of them probably don't enforce it. Whereas the spas, the clinics, the medical centres, etc., almost certainly will enforce those rules. If you take out your camera and start filming people as they're walking in, or worse still, they are likely to enforce those rules against you, throw you out, and prevent you from coming back. They can ban you from their place if they don't like what you're doing there. So that also in turn has an effect and a consequence upon the reasonable expectation of privacy. Do you have a reasonable expectation of privacy in a big open space such as this train station here, or any supermarket that looks a bit like this, quite frankly, from the inside? Do you have a reasonable expectation of privacy? In general, no, not really. There are certain areas that you might. For example, if there's a coffee shop with a hidden corner and you're there feeding your baby or whatever, and you're tucked away in the corner, and someone comes along with their phone and starts filming you, I can quite readily see you'd be upset about that. And if that went to court and you said that they were filming you and, breaching your right to privacy because you believe you have a reasonable expectation of privacy in that place, and them filming you is just wrong, then a court might take objection to that, particularly if it's a company or news company and things like that. Cases like that have gone to court. However, generally speaking, there's no automatic right to privacy in these public places, notwithstanding that the place might itself prevent you, restrict you from recording. But that's for them to, in inverted commas, police, rather than even the police, or rather than you to argue and so on. But as I say, you contrast that with the spas and the medical clinics and things like that, then you can then see, I hope, that there is a reasonable expectation of privacy in those places. So whilst the law might not absolutely spell these things out, there are various bits of case law that have discussed a reasonable expectation of privacy. Now, one other thing that has also come up in the response to this video, and indeed my video in response to that video, is the question of doorbells. Some people in the comments contrasted this with Ring doorbells and the Fairhurst and Woodard case that I did an extensive video on, again, a year or two ago, discussing all of the points there about filming and capturing video by fixed cameras. Now, the key difference here, well, there's three key differences. One, it was a fixed place of residence between the claimant and defendant. And secondly, they were fixed and permanent static surveillance cameras. They were just CCTV cameras or Ring cameras, but they were fixed, static and surveillance for the purposes of the definition. And so those had an impact on whether or not you have to comply with the Data Protection Act. Now, this comes up again and again, and I'm sure you'll see some comments in the box below, people saying that data protection law doesn't apply to individuals. You're wrong, it does. It applies to individuals if you've got a static camera at your home and it captures people outside of the curtilage of your personal property. If you capture people outside that are identifiable by their face or by their voice or a combination of the two, or taken together with any other information, then you have to comply with the Data Protection Act. It doesn't mean you have to register with the ICO. It doesn't mean you have to pay the fees, but you do have to comply with the law insofar as it applies to home CCTV domestic surveillance units. So, in other words, if they ask you for a copy of it because they've walked past, you do need to disclose it. And you can only capture as much as is necessary, hold it securely and for as long as is necessary, and so on. All of the principles of data protection apply, even to individuals, even in your own home. As I say, some people disagree down below, but they're wrong. That's the position. You do have to comply with it, unless, of course, it only captures your own property. Then you don't. But the third key difference in that case was that the footage was used to essentially threaten the claimant, in the sense that the defendant had threatened and had said, in fact, that it was sent to the police and various other things, when it hadn't. The judge just didn't side with the defendant. The judge found some of the account not credible, and thus did make a finding that there was a breach of data protection. In fact, as luck would have it, I have that judgment to hand, so I can show you the summary and conclusions of that. So in this case, there were claims for harassment and breach of the Data Protection Act and claims in nuisance. In reverse order, the claim for nuisance failed. For various reasons I've gone into in the other video, but the claim in harassment and the breach of the Data Protection Act succeeded. Harassment being a course of conduct, meaning at least 2 occasions that there was conduct that was more than the reasonable person should be expected to bear, and breach of the Data Protection Act essentially being that there was more recorded and stored and used in ways other than it really should have been. So if we go back a little, we can look at one of those such examples. The judge said, in relation to the audio personal data collected by the shed camera, driveway camera and Ring doorbell, I remind myself, the judge said, of the 3rd principle of data protection, that personal data shall be adequate, relevant, and limited to what is necessary in relation to the purpose for which they are processed. Processed is anything, really. Storing it, sending it, recording it, whatever. That's processed. This is the data minimization principle. As I said, only so much as is necessary. Then goes on to say, I'm satisfied that the extent of range to which these devices can capture audio is well beyond the range of video they capture, and in my view cannot be said to be reasonable for the purposes for which the devices are used by the defendant. Since the legitimate aim for which they are said to be used, namely crime prevention, could surely be achieved by something less. A great deal of purpose could be achieved without audio at all. So in other words, if you've got a camera on your door or on your shed or on your fence to catch thieves and burglars in the act, you don't necessarily need the audio, because if it captures audio and therefore the consequence is it will hear all of the conversations of your neighbour when they're in their garden or going out or standing outside their door or back door or whatever, that is more than is reasonable and more than is adequate for the purpose, which is to prevent crime. So in that sense, those cameras failed the test for being adequate. Now, looking briefly at the claim in harassment, did the defendant engage in a course of conduct? The judge was very clear that there was no doubt about this. A course of conduct is at least 2 occasions, and there were many throughout the judgment. I'll link this video overview of this case in the description below. It's a very interesting case. You could hear more about that. Secondly, did such course of conduct amount to harassment? And in short, judge said, I'm satisfied that it crosses the boundary between that which is just unattractive and even unreasonable to that which is oppressive. Now, this is a thing that a lot of people confuse as well. Conduct can be unattractive and conduct can even be unreasonable, but still not amount to harassment. But conduct which is oppressive and unacceptable, per this case here, it will cross that threshold into the territory of harassment. And therefore, the long story short is the claim in harassment succeeded. Nuisance is a very special one, and this case didn't amount to nuisance. But for all those reasons, the claim in harassment, this was one individual against another individual for the use of cameras at their residence because they were static, permanent, surveillance cameras. They were found not only to be a breach of the Data Protection Act, which some people in the comments, remember, are going to say that it doesn't apply, and here's a case by a senior judge. This was Her Honour Judge Melissa Clark. So a circuit judge took this case and said, I'm going to hear this case to determine whether these issues really amount to harassment, breach of data protection, and or nuisance. And the only one of those that failed was the nuisance claim. So for all of those reasons, there was a breach of data protection and harassment. But coming back to the train station, just finally. Now, first of all, if you took the videographer for this video as an individual or individuals, then data protection is generally not going to apply anyway. But the follow-up question is, if the use of this video by putting it on YouTube is not a wholly household activity, which is a fair argument, then the Data Protection Act applies. But then there are follow-up arguments after that. First of all, if someone is just incidentally included, then that's not necessarily going to cause any problems. Secondly, if someone comes up and actively takes part of an event which is being recorded and anyone could reasonably see was being recorded, then this is not likely to cause problems either. So overall, this is not going to cause any significant problem for data protection. So overall, I think this has been blown a little bit out of proportion. It was the filming an event in a public place in which there is no automatic right to privacy. And in this situation, there's likely to be no reasonable expectation of privacy because there's nothing about the nature and the circumstances that would lead to a conclusion that there was an expectation of privacy at that moment. But either way, I hope that addresses some of the questions and the comments that this video has attracted. If you found this useful, please do subscribe, because about 60% of you don't, and that's probably the only thing I ask of you, is to subscribe if you find this video useful. Also, thank you for allowing me the time to talk about my partner for this video. That helps me to continue bringing these videos to you, because I really do enjoy helping you to understand law. So with that, thank you very much for watching, and I'll see you next time.